Good morning and welcome to our case of the week for June 8th, 2021. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant, as well as the principal at ESI Attorneys. Thanks so much for joining me this week. As you know, if you tune in with us each week through our partnership with 𝐒𝐲𝐬𝐬, we choose a case from eDiscovery Assistant's case law database to talk about the practical implications of what it means for you, your clients, and your practice moving forward. For each of the platforms that we're live on today, you'll find links in the various platforms to on the events page, to the public link for the case that we're going to discuss today, as well, which is the Maker's Mark distillery case, as well as links to two other cases that are kind of at issue as a result of this decision. One is the 𝐒𝐩𝐚𝐥𝐿 case, and one is the �M15100 case. The �M15100 case is actually a case that we covered on week one of our case of the week back in November of 2020, which seems like a really long time ago, but actually wasn't. We've also just launched a new website at eDiscoveryAssistant.com, so please hop over and take a look. You'll find a new events calendar where issues are coming up as we move back to in-person events, as well as some webinars that are happening. And so you can check that out. You can also sign up for our blog at eDiscoveryAssistant.com/blog. All right, so let's get into our case of the week for this week. Our case is titled Maker's Mark Distillery versus Spalding Group. It is a decision from April 20th of 2021 from Judge Lanny King, who is a United States Magistrate Judge in the Western District of Kentucky. And this case raises some important issues and I think kind of muddies the waters a little bit on where we are with regard to self-collection. But there are some key cases or key issues in this decision to be discussed. As we always talk about in eDiscovery Assistant, we tag all of our decisions with issues. And the issues for this case include search terms, self-collection, failure to produce, and metadata, as well as proportionality. In this particular decision, so kind of diving into the facts of this week's case, Maker's Mark, which is a distillery that makes bourbon, and if you're from Kentucky like I am, you're very familiar with Maker's Mark. They entered into a licensing agreement with Spalding that granted Spalding an exclusive license and use of trademarks for Maker's Mark to create and sell cigars that were flavored with Maker's Mark bourbon. The licensing agreement was renewed a couple of times, and in 2013, Maker's Mark notified Spalding that it was terminating the license under the terms of the agreement. So we're looking at a time period of, from a business perspective for Spalding, from 1996, prior to when it entered into the licensing agreement, all the way up until December 31st, 2015. And that comes into play later when we talk about production of financial information. Under the termination, Spalding then had until June of 2016 to dispose of its remaining inventory of the licensed cigars. After the termination of the license, Spalding began to sell a different cigar that the complaint alleges was also seasoned with Maker's Mark bourbon. And the packaging of which Maker's Mark alleged was intentionally designed to evoke an association by customers between the bourbon cigar, which is what the new product was called, and the Maker's Mark and prior licensed cigars. So essentially, Maker's Mark was claiming that the Spalding Group advertised its new bourbon cigar in a variety of ways to associate it with Maker's Mark and the previously permitted licensed cigars, despite the cease and desist and the termination of the licensing agreement. So the allegations are essentially that Spalding caused actual confusion among retailers as to the relationship between Maker's Mark and the bourbon cigar. So subsequent product produced after the termination, titled the bourbon cigar, which should not have contained Maker's Mark and was outside the licensing agreement. And Maker's Mark claims that there was actual confusion. So that's really what the issues are before the court. In the context of this decision, the parties had proceeded with discovery. And to respond to requests for production from Maker's Mark, Spalding allowed employees to identify documents for collection using search terms that Spalding devised without input from Maker's Mark, ran those terms across Outlook, which is the email client from Microsoft, and then exported the results for review and production. And there are some other facts that we'll get into in the case, but the key here is that Spalding really permitted employees to do self-collection, that there was no ESI protocol. There is no ESI protocol that's entered on the docket between the parties. There was a motion for a protective order, which was originally denied by the court and has been renewed on this particular decision, although it's not really addressed. So what we have now is a motion to compel brought by Maker's Mark regarding the production of documents by Spalding, and Maker's Mark issues or raises a couple of separate issues, one of which has multiple segs in between. So the two issues raised are that Spalding sought additional 30b6 testimony. This is not really an ESI issue, except to the extent that when you're entitled to 30b6 testimony and the scope of the 30b6 testimony that you're entitled to is important. So that was kind of a minimal issue here in this case. The more important issue from an ESI perspective, and what I want to discuss today, is that Maker's Mark claimed that Spalding's search for responsive materials was inadequate. And there were a number of reasons that Maker's Mark gives, alleging that that search was inadequate. There are separately 5 different reasons in which they give. And I want to go over those, but more importantly, at the very outset of its analysis, the court says immediately that Maker's Mark has waived any objections that it has to Spalding's responses to the request for production because they failed to bring them in a timely manner. And the court states that as a general rule, when a party fails to object timely to interrogatories, production requests, or other discovery efforts, which here must mean responses to those production requests in terms of the documents, objections thereto are waived. The court notes that Maker's Mark waited 6 months to bring the issue to the defendant's attention once documents had been produced, and another 9 months to bring this issue to the attention of the court. The court then says that federal courts have found more timely objections constituted waiver, and that their failure to object earlier constituted a waiver. Now, what the court does not say is what that waiver practically means in the context here. What I think is interesting is as we go through the next elements of this court's analysis, that that failure to bring the issue to the courts earlier impacted the court's perception of Maker's Mark's argument. And so we've talked about this multiple times, but the timing of when you bring your objections to a court is very key. And it is really difficult as we engage in litigation to be able to sit down and come to terms with all the arguments that need to be made following a production in a really timely fashion. And the reality is that you have to. You don't have that luxury of waiting for several months until you want to get ready for depositions and then discovering what the flaws are in the production that you've received. So timeliness. Okay, so back to the adequacy of search. Maker's Mark argued that the defendants, quote, chose to employ a flawed search process without making any attempt to meet and confer with Maker's Mark beforehand, as required by the report of the parties, Rule 26 planning meeting, and request of the court, and asked the court then to grant its motion to compel documents and have Spalding develop a new search protocol in conjunction with Maker's Mark. So essentially, Maker's Mark saying, hey, you went ahead and decided what you should search for, and you didn't even talk to us, and our Rule 26 report requires that you talk to us first. Again, no ESI protocol according to the docket. So Maker's Mark then provides 5 categories of what it calls evidence to demonstrate the flawed process from Spalding with regard to its search. They alleged that defendants ignored the email account of at least 2 custodians, that the keyword searches were inadequate, that Outlook is an inappropriate program for discovery purposes, that the employees self-collected and made relevance determinations as opposed to an attorney doing it, and that the low number of emails produced implied withholding. So to each of those individual points, what did the court say? With regard to the custodians, one of the custodians the court looked at and found that based on his position and information that had been produced, that custodian really had no relevance to the matter. However, Spalding had offered to run the search terms across that custodian's email, the same search terms that it had already run across that custodian's email, and produced them within 3 days. Maker's Mark said, no, we still think your process is flawed and we don't want you to do that. Well, what happened is the court said that the process was fine. And because Maker's Mark had refused the offer from Spalding, it got no new documents. So the court essentially said, they offered, you rejected. As a result, you get nothing else. Now we're going to talk for a minute in which the court does the analysis of how it found that the key searches were adequate. But I do think it's worth noting here that this opinion kind of jumps around and is all over the place. It's a little bit hard to dissect just reading it, verbatim. So when you're taking a look at this, you've got to really take into account a lot of the facts that are piecemeal distributed throughout the opinion. They're not clearly stated at the outset. So it is really diving into a specific analysis of this decision. So as you are going through these e-discovery decisions, when you're writing your motions, make sure that you're looking at all of the individual facts and making sure that you're drawing analogies between the cases that you're trying to cite to support your arguments and the facts as they exist in that case, in this case. And in some instances here, at least the court does not address where Maker's Mark may have made some of those arguments based on previous case law. All right, so second argument with regard to the flawed process for searching by Spalding was that the keyword searches were inadequate. So there's not a listing within the case of what the keywords were that Spalding used. But what's really interesting here is that the court kind of drops the whole discussion of whether or not the search terms were adequate into a footnote. And that's a little bit problematic because, whether the search terms are adequate to identify relevant and responsive information is a pretty key point for purposes of discovery. What Maker's Mark argued is that Spalding didn't use any search strings with Boolean terms. They didn't create any search strings at all, but rather used single words like bourbon. Bourbon is the only term that's mentioned within the footnote or briefly mentioned within the case. And the judge actually kind of glosses right over the search term discussion, which is, I think, a little bit problematic because it's key to how you're going to identify relevant documents, particularly if you're going to use a search tool as would be built into Outlook. So again, judge just kind of glosses right over that, doesn't really address that the parties should have had any sort of collaboration or cooperation regarding search terms, and he doesn't address the Rule 26 report argument that Maker's Mark raised. Of course, Maker's Mark's arguing that the lack of search terms would have missed responsive documents, and that Spalding's search terms were unreasonably narrow and unsophisticated. Again, the court really just glosses right over that and says, based on the fact that the product was called bourbon cigar, it feels like it would have encompassed exactly what was needed. The next argument that Maker's Mark raises is that Outlook is an inappropriate program for searching. This again is dealt with by the court in a footnote, which is kind of surprising given the importance from an e-discovery perspective of considering whether the tool that the parties used to search for data was really an appropriate tool. I think without some actual test results showing the difference in search results between Outlook and another type of program where you would have collected a larger amount of data and input it into a review platform and then compared the search results you would get from Outlook to what you would get from the review platform, it's going to be hard to be able to to demonstrate to this court, based on this ruling, that Outlook is an insufficient tool. The court found, because the searches utilized were sufficient, that it really didn't see any reason why Outlook was not sufficient. Maker's Mark did make multiple arguments as to why Outlook was not an appropriate search tool. All of them were really dismissed by the court. Even where Maker's Mark asserted that limited search results would appear from Outlook, the court identified that employees would be able to be aware of additional search results in Outlook. So the argument is not well made or well analyzed by the court with regard to Outlook. It feels like, and perhaps the briefs on this case would have given us more evidence, but it feels like there could have been more built into the technical arguments of why Outlook is not a great search tool. Again, I really think that you'd have to do a test demonstrating the efficacy of the search term results between Outlook and a review platform in order to be able to show some empirical evidence to the court that Outlook was not an appropriate tool. The next issue that Makers argues is the failure to supervise. Essentially, it argues that the employees from Spalding were allowed to decide what emails were relevant and to be collected and produced. And Maker's Mark asserts, quote, that a proper search for discoverable documents requires careful planning, oversight, and monitoring by the parties' counsel. And they argue that by having the employees and not the attorneys determine which documents were relevant to the plaintiff's request, that they failed to provide the proper oversight and need to start again with a new search. Now, this is where we kind of get a little bit dicey. The court agreed that attorneys and not employees are the ones to make the legal determination of relevancy in discovery. But the court says, quote, however, while related, collecting documents and making relevancy determinations are distinct actions, close quote. That statement is problematic for me as someone who's constantly working with clients to make sure that we're identifying search terms, relevant information, and the scope of documents to be collected, because collecting documents is essentially a physical process of pulling out a copy of information that you have identified is relevant and potentially responsive to a request for production or to a preservation requirement. And deciding what's relevant comes later. So the scope of what is identified for collection should be slightly broader than what is relevant. And I think that the court loses track of that a little bit here, or maybe it's language that I'm interpreting differently than the court intended. But it feels like the court's making a big distinction between the identification of information, the collection of it, and then a subsequent relevancy determination. And they kind of go together. You know, you have to do some of that relevancy analysis when you're identifying information before you collect it. So that statement from the court is a bit problematic for me. Now, Maker's Mark cites to a case called 𝐒𝐻𝐺𝐬, and we've provided that public link to you in the comments on each of the platforms that you're looking at. That's also a case that's in eDiscovery Assistant. That's a case from the Northern District of Illinois in which the court did order a second review of documents following self-collection by the client by saying that there were smoking gun documents in that case. Now, the court here distinguishes the 𝐒𝐻𝐺𝐬 case because it says that in 𝐒𝐻𝐺𝐬, there was evidence of improper searching that prompted the new search being ordered. And the court also found that here, the attorneys instructed the clients on what was relevant, where he did not find that evidence of that instruction was available in the 𝐒𝐻𝐺𝐬 case. So essentially, the court says, look, here, Spalding's counsel instructed the employees on what they should look for, and that was sufficient as far as supervision goes. In 𝐒𝐻𝐺𝐬, the court found that although there was empirical evidence of smoking gun documents that were not produced, there also was nothing in the decision that specifically stated that counsel had instructed the employees on what to look for. So those are the two ways in which the court distinguishes the 𝐒𝐻𝐺𝐬 case. I still think that we're kind of walking a fine line here with regard to self-collection, and we're getting into what is required by counsel to meet its Rule 26G obligations with regard to supervising collection of information. I want to point you back to the M15100 case, which is also included in the links in your profile. And in that case, which again was our first case of the week, if you're a user of eDiscovery Assistant, you can go to the M15100 case and watch that case of the week within the platform. In that case, Judge Matthewman from Florida went through in great detail what the lawyer's obligations are under Rule 26G1, under Rule 26A1 and A3, and that the Rule 26G imposes an affirmative duty to engage in pretrial discovery in a responsible manner that is consistent with the spirit and purposes of Rule 26 through Rule 37. They also quote the Sedona principles on best practices. And so I think we've got a little bit of a difference here in what constitutes self-collection and what the attorney's responsibilities are with regard to providing oversight to the client. Is it sufficient to simply say, here are the things that may be relevant without looking at any of the data and making any decisions about what keywords are relevant? Is it appropriate to allow the client to come up with search terms without looking at the data, which it feels like is what happened here in this Maker's Mark case? And so I think that this ruling is a little bit different than the other rulings that we've seen on self-collection with regard to the M15100 case, with regard to the 𝐒𝐻𝐈 case. There are also other decisions that are cited by Maker's Mark in their motion, which the court distinguishes. And the court in those cases essentially holds that, or by distinguishing those cases, the judge here essentially holds that you have to have some kind of empirical evidence and not just be arguing about process. So you have to be able to show there are smoking guns, there weren't very many documents produced. You have to be able to show something that allows you to get a footing with regard to arguing that the process for self-collection was not appropriate. That seems to be a different bar than what we've seen in previous cases. In the M15100 case, there was evidence that the responding party had only produced 22 documents. Here, there's also evidence put forth by Maker's Mark that a minimum number of documents were produced. I think it was more than 22, but it was still a minimum number of documents. And so the question becomes, what is the scale that we're operating on to be able to test process as it relates to self-collection? There's not enough facts, I think, in this decision for us to be able to evaluate that effectively, but I think we need some more guidance. I think we need to know exactly what it is that a lawyer is responsible for doing, and I think that the M15100 case sets that out in a more succinct manner than this particular decision in the Maker's Mark case. Okay, final issue in the case was about the proportionality of sales and financial information. Maker's Mark had asked for additional information stemming back to prior to the licensing agreement. So back to 1996. We talked early on about the time period of the licensing agreement being 1997 to 2015. And Maker's Mark said, we want to see your business from the start of the licensing agreement all the way up until after the licensing agreement expired in order to be able to assess damages. And the court agreed that those documents were appropriate and that providing them did not produce or create an undue burden on Spalding to create them. Okay, so what are our takeaways from this case? We've talked about a couple of them already. One, don't delay in reviewing your documents and filing your objections. In this particular instance, 6 months, which doesn't seem like a very long time in discovery, was long enough for the court to say that you've waived any objections. And I think that that did have an input into the court's analysis as to whether or not a second search should be ordered for Spalding. Second, we talked a lot about this already. Does the court set a new bar on self-collection? What level of supervision is really permissible by clients? Is simply a conversation where they instruct the clients on what's relevant going to be sufficient? That doesn't seem to be sufficient in my estimation, based on all the work that we've done in reviewing data with clients. You're really shooting fish in a barrel by guessing at what search terms would be without having looked at data. But again, we don't have a very detailed recitation of what the facts were as to what counsel's level of supervision was in this case. I do think that the court's decision here that the receiving party has to provide some evidence of misdeeds versus just contesting the process is an issue. And I think that the court really does a de minimis analysis of whether or not there was sufficient supervision. The only note by the court is that some of the employees testified that counsel gave them instructions on what was relevant. Is that sufficient? I don't think so. We talked about the M5100 case. I do encourage you to go back and look at that as it pertains to self-collection so that you can understand exactly what your duties are in the jurisdiction where you're existing. I think the next issue from a takeaway perspective is when you're challenging the software that has been used to conduct searches or the search terms that have been used, you've got to be able to provide empirical evidence for the court as to why those methods are not sufficient. And it doesn't sound like Maker's Mark was able to do that here. I would have the same challenges to this searching that Maker's Mark had with regard to the use of Outlook, but there are empirical tests that would have to be done to be able to provide some information to the court as to why they were not valid. The question that I have in my mind with regard to all these issues is why the parties never engaged in putting together an ESI protocol to set out who the custodians were, what the search terms were. There's one important point that I haven't mentioned yet, and that is that the court does state two things. It says, one, that the parties have not cooperated at all during the course of discovery, but it also states that Spalding has been very forthcoming about the custodians and the search terms and the methods used to conduct a search during discovery. And that's a key point for the court here because it believes that by sharing all of that information, Spalding has put it on the table. And if Maker's Mark needed to object to it, they have to provide some evidence as to why it would be objectionable beyond just saying that the process of self-collection was not sufficient. That's our case of the week for this week. Thanks for joining me. I will be back next week with another edition of our case of the week from eDiscovery Assistant. If you're an ACEDS member and interested in using eDiscovery Assistant, there is a discount available to current ACEDS members and a trial for folks who are preparing to take their ACEDS exam. So if you're interested in either of those, please reach out to us at aceds@ediscoveryassistant.com and one of our team will get back to you. If you're interested in doing a free trial of our case law and resource database, please jump to ediscoveryassistant.com in the upper right-hand corner and sign up to get started. Have a great week. Stay safe and healthy, and I'll see you next week. Thank you.